Welcome to Laid Back Law with your favorite lawyers from around the interwebs, discussing the most pressing of topics every Friday at noon Eastern Time.
All right, as we are limping in and waiting for folks to arrive, we are finally back.
Yay.
This show has been a complete challenge to have on Fridays, and finally the Karen Read trial ends, and that week I think everybody was so exhausted they were like, I'm sorry, I have to catch up on my day job.
Yeah.
And then we had a 4th of July holiday, and nobody even answered me. I put it out there, I'm like, who could come on Friday? And it was just like ghost town. Don't know who you are.
You saw the tumbleweeds just passing.
Yeah, I mean, who are you? What's your name? I don't care about you. So we're back here. Let me get you in, Kurt. For some reason, it's not working well. Okay, we got Kurt here. Come on.
Hey. Hi, Kurt.
Eventually. StreamYard has changed their interface, and
it has, yeah, too.
When it's squished inside my teleprompter and I'm trying to use, I can't pull up a third person. So thank you, StreamYard. How about you make it where your buttons are accessible?
How am I supposed to co-stream now?
I don't know.
Okay.
They just did updates on StreamYard, so I'm not sure the whole deal on that.
Yeah, but we got a chat in window feature now.
Yeah. Okay.
Yeah. Which could be a good thing or a bad thing depending on the topic you're covering.
True. Well, I think Kurt also covered the Karen Read trial, so this is perfect. You guys both are very deep on Karen Read and Brian, what's his nose coming up, and
Kohberger.
Well, the Kohberger went by Brian Walshe.
Oh, okay, that guy. Sorry.
Yeah, no problem. We got a lot of Brian's in trouble lately, it appears.
Yeah,
but
Brian Higgins, Brian. Yeah.
All right, so let's wrap up on. We'll finally put the last Karen Read to rest. Nick was just telling me he did a video that's doing incredibly well about the missing dog in the
Chloe.
Karen Read case.
Where is the dog, Nick?
My guess is that the dog isn't anymore and hasn't been for quite some time.
Yeah, that sounds right.
But David Giannetti put out a picture on X where he said, "These are the questions I was supposed to ask of Brian Higgins that I will never know." And I took it. Oh, thank you so much for that high quality picture. Let's see what is on that table. And I saw there, you were going to ask a lot of questions about Chloe and Belgian Malinois. Wasn't she a German Shepherd mix? And then I found, somebody found the license the Higgins put in to have her in there. And then it's put in that she is a German Shepherd mix. Yeah, but mixed with what? Because if it's a German Shepherd mixed with Belgian Malinois,
mixed with lies.
Yeah.
Well, the Belgian Malinois. Hold on, I think it's kind of relevant. If I recall, that is a very high-tempered dog that you have to train very specifically. They're a good dog, but they need a very firm control, specialized training, and just not generally considered great for a family pet.
Yeah, extremely protective, as in there is no way on bad curse words that that dog was silent during all the commotion outside. Chloe was already long gone.
The dog that didn't bark.
The dog that didn't bark, yeah.
No, it bit, didn't bark, or allegedly bit.
Allegedly, yeah. We have to say allegedly.
I don't have to say anything.
but fair enough. Okay, so Karen Read is done. She got a DUI charge, and moving on from her. But that area of town, apparently the problems have not ended, especially for the illustrious reporter Turtle Boy. Was it Adrian Carney?
Yeah.
He's somehow mixed up in another case that involves a missing person or murder. Well, what's going on?
The Brian Walshe case. Yes, Brian Walshe. This is a guy who, just looking at his interesting Google search, it says, "Oh, this is damning. This is very damning. How to all the bad searches, how to get rid of a body, how long does it take for a body to decompose, on and on and on and on." Problem here is they did not have a search warrant for his phone. They had
that wasn't a problem for Proctor when he started the search of Karen's phone either.
No, I mean, yeah,
he didn't have a warrant at that point.
Yeah, and so
same
they
department, same cops,
same department, same cops.
Training issue here.
Yeah, and so they had he voluntarily gave up his phone after his attorney and the prosecutor said, "Yeah, you can look for these specific things," and that are communications between him and his wife between December 25th and January 6th or something of the sort. And they downloaded everything and looked through absolutely everything, including Google searches.
Of course it did.
Yeah,
it's all plain view now, don't you know?
Yeah. So they had a big hearing about that some time ago, and that did not go well. But the judge hasn't made a ruling yet for some odd reason. But so this is a case where very damning evidence against Mr. Walshe might be thrown out due to fruit of the poisonous tree.
Right.
And
because you didn't do what we told you to do.
Yeah.
Yeah.
You know, that's a interesting, I don't know if you guys are into history or anything. I've had somebody on talking quite a lot about Son of Sam murders. But a lot of people don't realize that David Berkowitz saved the police's ass, if you will. When they tracked down the parking ticket and they realized, holy cow, this guy, David Berkowitz, he had a parking ticket in this area. They went to his place. They saw his car, broke into his car and found the guns. And then they said, oh shit, closed the car up and everything else. And then he got arrested and everything else. But there were very real questions whether the whole case could be thrown out because they, I mean, all the things were there. The murder weapon, the guns, etc. in his car. Not a good day. But fortunately, he kind of went off. He's like, yeah, I did it. And they were like, okay, he said he did it. And I think that's part of why he is still in prison.
Yeah, and in this case, they are going for in plain view for the Brian Walshe phone.
Right, of course they are.
Of
course they are.
Yeah, because it was in plain view. After searching for 2 hours through the phone, they found the Google searches in plain view.
Okay, help me understand. There. This is in plain view. Does that mean that everything on it you can now see? How?
That's what they're going with. Yeah.
Okay, I'm not a lawyer, but that doesn't sound quite right to me.
It's remarkable, and you have the Karen Reed case, the Brian Walshe case, and also the Sandra Birchmore case is involved. It's the same cops, and most of them are getting rehomed now and thrown out of the DA's office. And
I'm sorry.
And it's a very, very proper fustercluck of events that might lead. Well, we kind of know that Karen Reed had nothing to do with John O'Keefe's and demise. We know about Sandra Birchmore that she was groomed and raped by cops, plural. And we now know that their incompetence might get Brian Walshe off because,
wow,
yeah, it's the same set of cops.
All right, well, you know what? I hate to change the direction so quickly, but you gave me a segue. Incompetence. Can we go to SCOTUS?
Yeah, yes,
please,
we
let's
can.
do.
Yes, we can. The drama is real.
Oh, take us there, Kurt.
Oh man, I mean, just like Ketanji Jackson, when she is being like, and even Sotomayor is like, I can't deal with this shit. When even Sotomayor is off the rails, It's like, goddamn.
I think Sotomayor joined with Jackson at least once and maybe twice, just out of pity, but just so that she wouldn't feel like she was all alone and she's a minority.
Yeah. But no mas.
Reached the point where Sotomayor said, "This this girl needs tough love because she's not getting it. She is not getting it."
She also speaks like way more than any other justice, like by a factor of like 2 to 1 or something, or even more. I forgot. I saw the stats. The amount of time she speaks is a lot.
Yeah, and not much to say.
And not much to say, right?
No, there isn't. But it's the last opinion that came out about the Trump's workforce reduction. Sotomayor basically, I think, has washed her hands of this. Said, "Look, I tried to talk to you privately. You're on your own now."
Yeah, I think I read that. I read it that way also. It's like I'm tired of just trying to defend you. I don't know where the hell you're coming from at this point. It's very frightening actually, because she's likely to be the. She and Amy Coney Barrett have the longest expected remaining Supreme Court time.
I don't think so. I think she's going to quit. Not during
Jackson.
Not during a Trump. Not during a Trump. Not during a Republican administration. I think she's going to hate life. There's incredible opportunities for her adorning the top of some left-wing organization or law firm's letterhead.
She likes money.
This year, it could be 5 years from now, but I don't think she is prepared to spend the rest of her life being the butt of everyone's jokes. And
that's kind of late.
Well, so Ron, do you think she'll potentially get a book deal and can cry victim in the book and then be marching around the country how she was being picked on and misunderstood, even though she had the stellar ability?
So like that lead anchor slot on MSNBC is looking real good, man.
And there's a 7-figure annual comp, position just waiting for her.
And 20
maybe her account got hacked. Have you thought about that? That's a good excuse. Everywhere else,
Cerebellum got hacked.
Well, no, I heard she was using AI to write it. So maybe she used Grok instead of ChatGPT.
That is insane.
I don't know.
And yet,
when Amy Coney Barrett wrote in that opinion, basically, "You are too stupid to even respond to. This is so far beneath me, I can't even merit a response, except to note that you apparently oppose a imperial president but support an imperial judiciary." When John Roberts signed off on that opinion, because he was a co-author of it, I'm like, that's a pretty big tell. Because John Roberts, like him or not, he's concerned about the institution of the Supreme Court. He's concerned about its reputation, and he's concerned about the legitimacy of the Supreme Court, and he will compromise his decisions in favor of institutional, concerns. And so the fact that he was apparently willing to throw her under the bus in such a brutal way, I'm like, Jesus Lord, what is going on over there?
And I was going to say, it got even better because right after that opinion came out and she's railing about the rule of law, the rule of law, the rule of law, this district judge in Massachusetts defies the Supreme Court. And when that one comes around, even Kagan's like, look, the game is the game. You got to follow the rules. And yet, what does Ketanji Brown Jackson do? Yas, queen, don't obey the rule of law.
That is amazing.
Yeah,
the fact that a Supreme Court justice is apparently okay with a lower judge defying the Supreme Court is so mind blowing. It's hard to even comprehend.
And Sotomayor went along with that one. She went along with that. She's like, that's fine. That's
what the hell are you talking about? What part of Supreme do you not understand in this sentence?
Is it me, or did the other justices treat her almost as if they were overruling a lower court? Like the verbiage is something they might have used to a appeals court judge or something rather than a peer on the Supreme Court. And have any of you who've been following Supreme Court for a long time, have you ever seen any writing like this over one justice or another?
Really?
Yeah. I mean, if you read the dissents in Obergefell, even, both Roberts and Scalia, I think, filed dissents. They were pretty pissed off. They really expressed that they believed that the court had really run off the rails. I just think that this particular, the reason it reads the way I think that, Eric, the reason that you're getting that impression is that this is a new kind of dumb. I mean,
well, it's an old kind, just new for the court.
But there's been lots of dumb in lots of Supreme Court opinions for lots of years, for since go almost. It's amazing what judges will sign their names. I just got a Ninth Circuit opinion affirming a district court that was so wrong on so much, and they just, after 4 months, they just decided, we don't give a shit actually, and it was, judges have a tremendous amount of power, and they I don't know what happens when a judge decides I don't give a shit anymore, but seeing it at the Supreme Court level, where a judge is even willing to say, Supreme Court justice is willing to say, I'm prepared to cede my power as a Supreme Court justice to political correctness.
Mm-hmm.
That's something new.
It's
usually you can count on justices to be jealous of their own power.
That's what I would say. Like, it's like, even if you were going to bend your decisions for purely political reasons, the fact that you aren't going to hold lower courts to that is insane.
No, but it's also it's even worse than what Ron is perhaps laying out here, because we've seen justices bend the law and justify how they would bend it. What we saw from Jackson when she went on that black entrepreneurs or something like that, there was something she did like.
Oh yeah.
She essentially said that now, because she's on the Supreme Court, she's in a position to just opine and work based on her opinion, and implicitly admitting that it's got nothing to do with precedent or statute or what was supposed to be dictating the decisions of a judge, but how she feels. That she says that this is my opportunity to express how I feel about certain issues and how things should be. That is like, she's basically treating her dissents like it's a Dear Diary. This is how mad I am at them for saying this. And for a judge to actually come out and have the audacity to admit, to take off the fig leaf coverage of, I look at the law this way, and that's the distinction here, and basically say, no, I'm not trying to work within what the boundaries of statute and precedent say. I'm just telling you what I think is right, and that's how we're going. That is new. That is I don't know that any justice has ever been that brazen in admitting that their motivation was something that was their personal feels rather than what the law dictates they're supposed to do. That is scary. That is and if that's the direction we're going to see from other justices, that is anarchy. Because now people are perfectly comfortable, and it starts with being comfortable with admitting it, and it's moving, and the way she's proudly expressing it's moving towards being prideful. Like, I'm proud of the fact that I'm ignoring law and precedent, and that I can basically be in this position where I can tell you how I feel because I'm so special. And when you start getting more and more justices like that, as we march forward in time, a decade, 2 decades, 3 decades, you can see a complete unraveling of how our judicial system ultimately will unfold.
I mean, Justice Scalia once said that one of the marks of a good judge is the fact that they'll make decisions that they don't themselves actually agree with, because it's what the law demands. And I think that's right. 100%. Because sometimes as a judge, you're like, well, this law is not exactly what I want to be. And sometimes it might hurt somebody that I really don't want to hurt, but there's no way around it. So I have to make a decision that even I hate. So I suppose the question, which we already know the answer to, is, will Justice Jackson ever make a decision that she herself doesn't actually agree with?
And she just said no. She said publicly, no, I won't. This is my opportunity to tell you how I feel about things. It's a very scary perspective, because I fear that this is a direction we're going to be seeing from more and more justices as more are added to the court over the next 10 years, 15 years, 20 years. And especially when you look at it's much scarier and much more likely, you would think, to happen from the left than from the right. And the reason for that is because they look at, they've always come, they've always come from a perspective of the Constitution is a living, breathing document rather than originalism and textualism. That has been the coverage that they've relied upon to have that fig leaf veneer, meaning they've been moving in this direction for a long time. They've just never been as brazen as Justice Jackson was. They've long held to this ideology by inventing this concept that the Constitution is a living, breathing thing that we can reinterpret however we want. But now she's given herself license, and perhaps license to other judges, and if she's doing it at this level, it happened at the circuit court level, district court level, any level, to basically say, I don't have to be bound by statute and precedent, and based on what I feel is right, since I've been put in this position, that gives me a license now to basically write law as I feel life should be. And it's it's horrifying.
The thing with the living, breathing,
Rod.
The thing with the living, breathing philosophy is like, what would happen if the right wing actually adopted that? How would that work out? It's like, you know what? We've changed our mind. We're all about that living and breathing thing. So we're going to make the Constitution what we think it wants to be because it's living and breathing. I don't think they would be pleased if the right wing started adopting that philosophy.
I don't think it's going well for her, Joe.
No.
What do you mean it's not going well for her? For Jackson?
I don't think other judges and prospective justices. First of all, there's now a question that Republicans, whether in the minority or otherwise, can ask on the Judiciary Committee. Do you agree with this statement of Justice Jackson that it is the role of a justice of the Supreme Court to impose new doctrines and theories of jurisprudence on the on the judiciary and to interpret the Constitution? But also, she's lost Sotomayor, she's lost Kagan, and I think that's going to be noticed by the future justice.
Respectfully, Ron, and you know I love you. You're right. You're right. The reason history dictates you're wrong. History dictates that it starts with one person being brazen enough to do something that no one else would do. And at first, they get slammed down and clamped down, and everyone's like, you're crazy, you're an idiot. But that starts becoming normalcy. That starts becoming the direction that we go. You can look at it in warfare. You could look at it historically, going back literally 3,000 years to Amalek. You can look at it to
selection bias, Joe. Selection bias. You're looking at the times when that has worked and disregarding the majority of times.
Today's black pill brought by
it doesn't work. It doesn't work right away. I'm saying it's not something that we'll see now.
She's moved the Overton window.
We have to look at American jurisprudence going forward 50 years from now, not 5 years from now.
You're saying she has moved the Overton window. It's now acceptable because it came from a justice of the Supreme Court to be that far out and be allowed to keep your job.
I mean, Scalia basically invented our modern version of originalism. Originalism was a theory before Scalia, but it had been disregarded and discounted and seen as very antiquated for some period of time before Justice Scalia came on the scene. He basically revivified, if not invented, originalism, which is now the dominant theory in legal thinking. So it definitely can happen.
Can you guys break that down really quickly for the layman, aka me? Of originalism versus living document versus textualism?
Yes. Yeah. So originalism is basically looking at you look at the language in the statute and you say to yourself, okay, what were they thinking when they wrote this? What was the motivation that they put into this law? How did they think this was ultimately going to affect society? And how did they feel it was going to be enacted? And let's use that as the basis for understanding how we should be interpreting this law. Okay. So
how do you determine that? With the Federalist Papers, Anti-Federalist Papers, and stuff
precisely.
Like that?
You could look back at debates that Congress had. You could look back at different things, at the contextually in time, what was happening in the society at that point in time. So we'll look back at the 13th and 14th Amendments, and we'll try and look back at the problems that Congress was dealing with at the time that they enacted during that Reconstruction period, and what they, it's logical to deduce they assumed how this statute would work. Then you could look, that's an originalist perspective. The exact opposite of that is living, breathing document, where you basically say, well, I can read this. I can read this word as they meant it to be this, but similar to along those lines, let's also read in this thing here that is not anywhere contemplated. We know they weren't thinking this at all, but given that society has evolved and society has changed, and we have this statute there, so this now gives us an opportunity to sort of use this statute and say, okay, if they were around today, how would they do it today? Or pretend that we know how they would approach today if they were part of modern society, and accordingly we can morph this. So that was the notion of.
But isn't that what amendments are for?
Well, that's
not to be dumb, but are amendments literally to say, okay, things are just too far with society as is, whatever. We have to have an amendment. It's very difficult to do, but we can correct the document with it.
But beginning with the Warren Court, and to some extent, really the New Deal, the court that was intimidated by the judge packing scheme, for the last 80 years or so, the Supreme Court has decided that amendments are just too much trouble. And they're going to find in the Constitution what they want to find there.
Right.
And
I'm sorry, go ahead.
I was just saying, I could give a more technical answer to your question if you like. Okay. So there are several major modes of thinking in legal reasoning, and what originalism is and what living constitutionalism or living document is different priorities of the underpinnings of the major theories. So the major theories are textualism is a major theory. Literally, what do the words say and what do they mean literally at the time by a dictionary? History. What was happening that caused this text to come into being? Like what was happening in society? What was Congress trying to respond to? What was the situation? Why did they write these words from a historical perspective? Then you have the intent. Putting aside the words to some degree, what were they trying to do? What was their goal or motivation? What were they trying to incorporate? Precedent. What has been the legal history of this? What have been the legal cases and legal decisions leading up to this? And the last one is policy. What would be good to do from a policy perspective, like a politician? So politicians, by their nature, focus on policy because they're like, what would be good? What should we do? Should we fund breast cancer, or should we fund prostate cancer, or should we fund skin cancer, or should we fund, this other kind of cancer? That's policy, right? So what an originalist is a mix. So a textualist, as the name sort of implies, is someone who just kind of goes straight to textualism as a theory. They use that theory and kind of ignore everything else. Originalism is a blend of theories. They use textualism, they use history, and they use precedent, principally. And what living constitutionalism is basically dominantly policy. It's dominantly just policy. What would be good? I'm a legislature now, and I'm just going to tell you what I think should be, and I'm going to twist legal reasoning into enacting that. So that's what it is from a technical perspective.
Well said. Well, you should be teaching constitutional law.
So if we look at the current layout of the court, judging by their decisions, obviously it's interpretive. Who would be what? I'm assuming Clarence Thomas is an originalist. Gorsuch.
Gorsuch is a textualist.
Oh, okay. All right. So tell me the breakdown of all of you. Who is what? Because then that can kind of give us an idea of which way they go. And I'm speaking like I've listened to Robert Barnes a lot. He claims that there's like an institutionalist wing of the Supreme Court with Roberts and Amy Coney Barrett, that they kind of they're not exactly the same as a Clarence Thomas or whatever. So can you guys break down
when you hear about institutionalism and that kind of concept, the notion is that a judge may claim that I'm an originalist. A judge may claim that I'm living, breathing, or whatever, that I embrace this philosophy. But a lot of people speculate that they're guided principally by, and they start with, this is where I'm coming from as far as what my agenda is, and then I can find some way of interpreting the Constitution to justify the result that I want. So if you're an institutionalist, so in that case you say, okay, so our American institutions, that what keeps us strong, what keeps us going, what has made us successful for 250 years, and they basically will look at these things that we need to uphold these. So belief in the government, our belief and trust in our healthcare systems, in our businesses, these sort of things things are what keep America strong. So even if so, an institutionalist is basically guided, and that's not just in a judge. That could also be with someone who's in the executive branch or anywhere else. They're basically guided by like, I need to do things in order to help maintain these institutions. So if I think it's good for the institutions, that's long-term beneficial to America. So now, as when you're doing that, applying that as a judge, if you're starting with that's where I want to get to, you can use any of the directions that, or whichever direction that you think will work best for you as laid out by uncivil law to reach the predetermined conclusion you want to get to. So these institutionalists, which most people refer to as Roberts, Coney Barrett, and Kavanaugh specifically as being institutionalists, is they are very big believers that we need to uphold the institution. So I'm going to interpret the Constitution and approach my decision here based and employ whatever legal theory best works to help reach my predetermined end. And that's the concern that Robert Barnes, and I agree with him on this. I think that, and you can even apply it, by the way, not just to institutionalists, but you can say a conservative has an objective that they want to get to, and they'll approach it that way. That's what the left will say about Thomas and Alito. And when we look at the left, we look at it as like they're either going to try and use some living breathing, or they'll be completely untethered, like we've seen from Justice Jackson. So that's the different ways. That's my breakdown here. But if you guys have more you want to add.
This is a different axis, though. In other words, people have to understand that institutionalism is in and of itself not inconsistent with originalism. The question, to the extent that we're saying someone is fundamentally or mainly about this, we're saying that that's what's on their mind most when they consider their mission.
Well,
what is your judicial philosophy, and one is really kind of a political philosophy. But the opposite of a textualist or an originalist is a living constitutionalist.
Yeah. One thing I think it would behoove me not to mention that all the justices kind of go through each one of those theories. For instance, Scalia was Justice Jackson when he first got. Remember, there was this ruling where it was 1-8, where he was the lone dissenter, and they were like, he's crazy, but then his dissent happened to be the best opinion, and now it's the one. Which one was that? That was the,
Morrison versus Olson.
Morrison. He was the lone dissenter.
Great dissent.
Justice, yes.
And now it's basically the law.
Exactly. He was the Justice Jackson back then. He was like, this guy's crazy. He's a new judge. Blah, blah, blah.
I have a feeling that both those justices would resent that remark you just made.
But he was. They may. But he was, in terms of just the way that opinion was looked, his dissent was looked upon.
Yeah.
And now it's sort of, and it wasn't well, actually that dissent was more of an originalist dissent. He was going to more of the originalist dissent, and the court itself was taking more, even though they were more conservative justices, they were taking a more progressive opinion. But I think now, unfortunately, what I think a lot of people don't understand is that if you look at all of these opinions, even the older opinions and newer opinions, they switch back and they kind of use whatever philosophy best describes for that means to an end. And I think Roberts is really good at doing that. He did it with Obamacare, and he did it really well when it came to I forget the other case that he did it, where he took a more liberal approach to it. So none of them are pure. One of the biggest ones was Scalia in the gun case, where he essentially made up the individual right to bear arms for all of history. And people also forget about like the ghost of Locke. This has always been
made up.
Yeah, I don't know about that.
Yeah, he essentially there was no individual right to a firearm. And McDonald, they essentially said, guess what? All of a sudden, there is no right. And everybody was saying he's not being an originalist. It's not, it wasn't an individual right. It was a state right, and then it became an individual right. And
I'm confused. Hold on. Wow, help me out on that, because I thought the Bill of Rights were all
I don't know about
individual rights.
So,
like freedom of speech, I thought that was an individual right. And now help get me unpacked here, because that sounds completely crazy, Nate. I apologize.
The issue in the Second Amendment was the comma of all commas. In the Second Amendment,
I thought it was a semicolon.
Maybe a semicolon.
Well, Nate,
but
it's a comma.
It's a comma.
Remember, McDonald was about the incorporation, though, so that was why they're saying,
but
it's like
DC versus Heller.
It was Heller.
So, Heller just said you had the right, that McDonald was the incorporation of that,
right?
And then, and I thought the argument was funny. It's like, oh, well, you're not being original. It's like, So you agree that incorporation's a bullshit legal argument. And they're like, well, I don't want to go that far. It's like, well, then they're all incorporated or they're not all incorporated.
Well, even Thomas.
Well, they've
said they're not all
declined to
incorporated.
incorporate a couple ones. They declined to incorporate grand juries, and there's something else I think they
It's not all
declined to
of it.
incorporate.
To answer Eric's question, though, so what happens is before the individual right to bear arms was given through by Scalia in Heller, I believe it was, going back, the right the Second Amendment was always a state right, the right of state militias, and that's kind of the jurisprudence up to that point. And it would, even though it's kind of like, yeah, you may have an individual right, but the right was the right of the state, and it was the same thing like with abortion, like each state can kind of choose whether they're going to do it or not. And then Scalia said, well, no, it's an individual right, and now constitutionally everybody had to do it. And that the argument was that he wasn't being an originalist, he was changing the Constitution. He was reading something into it, and the whole argument came down to a comma, whether the comma.
I disagree. I mean, I'm not a lawyer, but it just every part of my carbon disagrees with that stance that, to me, the Bill of Rights are individual rights, and maybe the state comes into it, but I mean, from one on down the line, it's, I've always understood that the Bill of Rights these are your God-given rights, as in these are the rights that God has ordained upon the people or whatever, and the state shall not screw with your individual rights. Now, I'm not putting it eloquently, but that's the way I've always understood it. So.
In fact, before you respond to that, I just want to point out, by the way Eric explains it, which is how I understand it also, the Second Amendment does not merely give an individual a right to own a gun. It actually implicitly gives an individual a right to form his own freaking militia and arm them with guns.
Or knives, or any other weapon of any kind, because an arm isn't just.
We have a little law to militia, right?
Yeah. So what you guys are talking about is what you guys think the law should have read all since the beginning. What I'm talking about is how the law was practiced before Heller. The reason why there was a Heller is because that was the question: did you have an individual right? And the question was answered before Heller. No, it wasn't individually yours. It was a state right, and the state can give you the right.
It had only been answered by the appellate courts. It had never been decided by the Supreme Court.
But that's what I'm saying. The Supreme Court eventually, and you had the circuit split. There was a circuit split with it too. And then the Supreme Court said, no, it's an individual right.
I mean, it's certainly true that the dominant thinking was that it was an individual right by the lower courts. That had been the law basically dominantly, but it was the first time the Supreme Court ever answered the question. They overruled all the circuit courts, which sometimes happens. Is like, yeah, you're all wrong.
So you're agreeing with me. So that's what I'm saying. Though Eric is saying, well, I always thought it was an individual right. That maybe the way he thought about it, but the court for sure, the federal judiciary didn't think about it like that until Heller said, yes, this is the way it is. There may have been some cases that said maybe, but Heller was the one that said yes.
Instead of arguing about guns, I just want to point out, if we want to be timely, we can apply this conversation to birthright citizenship and basically talk about what the language of the statute is versus how it's been interpreted. And because I think that this is a perfect, and that's obviously something that came up just this week. On January 20th, 2025, Trump changed the right of birthright citizenship and passed this EO. And then there was this whole issue as to that EO being stayed. And now it was restayed with the class certification. And the question, I think this really calls to mind exactly what Nate is bringing up here. You might have the text of language saying it one way, but for the last 70 years, everyone has understood that, hey, the reality is, if you're born in this country, it doesn't matter whether you're a visitor or a legal alien, that the kid is going to be a citizen. So even if the statute doesn't say it that way, I think that's when, Nate, correct me if I'm wrong, is that not where you're going with this whole gun thing that you're saying?
Couldn't that be sloppy writing? No, I agree with you, Joe, on that, because I would argue the birthright citizenship is sloppy writing too. If one word had been put into the whole thing, there would be no question. If they said stateless, then there would be no question that it was, for the children of the slaves or former slaves or whatever, because they were stateless. They had no country of origin in any way, shape, or form. Same thing with the Second Amendment, which I think a lot of people have said is just really kind of sloppily written. But I'm sorry, jump in, Nate. I just want to interject my silly views.
Sorry.
Well, the Constitution was kind of written in a way for it to be interpreted by the judiciary, so it's kind of given that it's never written. It's always written to give you some leeway. But I agree with Joe is that now we get into the birthright citizenship issue is going to be the same exact thing. This is how it's been interpreted for the past, however long it's been. And now that there's a challenge to that interpretation. And I would say it could go either way. But the same thing with abortion. Abortion, the abortion people make that argument that Joe just made. For 50 years, it was a constitutional right. It's been interpreted this way. Now they're changing it. So the court, when they changed the abortion, they would say that court wasn't being originalist. It was being progressive. It was changing it for a different reason. So it's right now, to be honest with you, it's really what the court tells you what the Constitution says and how far it goes, and we just kind of have to live with it. No matter what's on the page, no matter what's on that page, it's the court who determines what it means.
What about the argument about the word stateless?
Stateless.
Well, that opens it up to a lot of other Palestinians, for instance. They are stateless. If they came here and had a kid, then they would be U.S. citizens. Like stateless, then opens it up to a lot of different other things.
I'm like, stateless is not
lower.
Stateless is not our problem. If someone's going to be stateless because they're not a U.S. citizen, that is not our problem. You don't get to magically just be a U.S. citizen or presumably any other country of your choice because you'd otherwise be stateless. That's insane.
Well, I said very specifically to the point of time that they wrote this, and they said born here, and they were trying to take care of a problem at hand. Now you're going and leaping forward to the future, Kurt, like right now, and saying, "Oh, applying the world here, that just makes no sense. That's insane." But I'm talking about when that was actually written in the birthright citizenship, responding to the slaves, and if they had added the word stateless, you're right. Maybe more could slide in. Maybe the Palestinians could in this day, but we wouldn't have had nearly the influx and the number of people who, shall we say, have obtained this particular status. Is that a fair point?
I mean, I suppose, but it all boils down to what is the proper interpretation of the 14th Amendment when it says persons born in the United States and subject to the jurisdiction thereof. What exactly does that mean? That's the legal question. And presumably, whatever that means, one way or another, whatever the proper interpretation of that is, one way or the other, then that's just the right answer. To the jurisdiction. What does that mean to be subject to jurisdiction?
Well, if I go to England and rob a store and I get arrested, I can be tried, convicted, and put there. I'd be subject to the jurisdiction in England if I did a crime, correct, or any other country in the world. So that's whatever.
That's not considered subject to the jurisdiction. At least when they wrote the 14th Amendment, that was not what they had in mind clearly, because it didn't refer to Native Americans. And in theory, we could have gone in there and wiped them out, and we could have sent our army in there and wiped them out. But
they had their own country and they had their own borders. So no, I don't think it's the same thing. Now, if we did a crime in their
borders.
Native Americans, reservations are actually their own country. It's negotiated within ours. That's why you have the federal thing. It's one of the most confusing aspects in the world. But I disagree. If you're talking about Indian reservations and tribal lands, this is technically another country. It's another jurisdiction.
Yeah, and just to be clear, the 14th Amendment has exceptions. Diplomats, for instance, and indigenous people or Native Americans are exempt from the 14th Amendment.
Well, it clearly wasn't designed to cover Chinese people. At the time, there was a real racism against Chinese people specifically. Sure. And the whole Wong Kim Ark case that the left loves to cite to, I think it actually proves the exact opposite point from how they try to use that case, as far as historically what was intended here, in the sense that Wong Kim Ark was decided in favor of the petitioner in that case because they had a permanent residence here and established their permanent residence. That's why he's deemed a citizen. That's why the child is deemed a citizen. If they don't have that, they're just a visitor, they just set foot on American soil 10 minutes ago, then in that case, Wong Kim Ark is clearly implying that you would not be entitled to birthright citizenship. And accusingly,
how long before we say that you're a citizen? So
you have to at least establish that the person is using America as their permanent residence, and then have a child. I moved here last week.
I'm home. It's my permanent residence. So now let's have the kid. I mean, I'm saying that there's problems even with that. It's like, at what point is this a permanent versus a not? Now, obviously, you can make the argument, hey, they've been living here 20 years and then they have a kid. It's like, hey, this is pretty long term. But
you can create
give me a timeline.
you can create yardsticks for what makes someone deemed a permanent resident. I don't think that's a problem. It's that I mean, and I'm sure that yardsticks under the law probably have been established as to what makes someone a permanent resident. I can't list them, enumerate them for you here and now, but that doesn't mean that there aren't yardsticks to help establish what a permanent resident is. But the point is that whatever steps you need to take to become a permanent resident, once you establish that and then have a child, in that case, under Wong Kim Ark, I can understand the point. But if you don't have that, then clearly that's a shortcoming. However, Nate is correct that for the last 70 years, when you went to school, I can guarantee you, any one of you who are watching this, when you went to school, if this issue came up in some civics class and you had a school that was based enough to teach you civics, in that case, you probably learned that anyone who's born in this country, irrespective of their parentage and the status of the parents, is a citizen. Now, that was probably wrong under a proper reading of the statute, but that doesn't mean that that wasn't what our society has come to accept for a long time. And that leads us to question how will the Supreme Court react to this when inevitably this issue comes up before the Supreme Court as to the validity of Trump's EO.
Well, hold on. I for Wong Kim Ark, from what I remember, he was born to immigrant parents who were not able to be citizens, and the Supreme Court did the analysis and said, well, they're not diplomats and they're Native Americans. So in that particular instance,
They're Chinese.
Well,
they were Chinese.
Chinese. I'm saying, yeah, Chinese. But they were not able to get anything, and they were saying, well, the kid was born here. He's a citizen. They're not. So,
but they were lawful permanent residents, I believe.
Yes.
Yeah,
that was a key element.
So now, is there a case that establishes? So the issue would be illegal immigrants, so people who are here illegally.
Yeah, there's no case.
They be that, and there's no case on point for that. So that's the issue that we're talking about.
Yeah.
Okay. Right. But the point is that you can deduce from Wong Kim Ark that being a lawful permanent resident, or what they call an LPR, is an essential ingredient towards giving that newborn birthright citizenship. And
but
that absent that, you don't have anything.
But I think the argument against that would be dicta, because in the opinion itself, the analysis was whether they went through any of these recognized exemptions, diplomats, and they didn't go. They recognized that they were lawful permanent residents or lawful residents, but they did not. That wasn't
who were here legally. Who were here legally.
But the holding wasn't because they were here legally. It was because they did not fit into the exemptions. Like you've used the dicta and placed it in a holding, but I think the holding is clear. The holding is clear.
I got when's the last time you read that decision, Wong Kim Ark?
And I think law school.
Yeah. So,
but I remember that was the argument that was being made, though. The argument was being made was this part was dicta, this part was the holding. And
it was so much easier when I went to law school. There were only like 13 or 14 reported cases.
It was just Marbury. That was the new one.
In total, no.
All right, let's shift topics.
First, can I, as an adult, be legally adopted into the United States? Because I really want to retire there now when we lost our freedom of speech over here.
I mean, you could be adopted, but that wouldn't necessarily make you a citizen.
Yeah, but that's what used to happen. Those are the gay marriage cases before gay marriage was legal, where gay couples, one person would marry the other person, so they would have all the rights and privileges of a family member. So there was a whole bunch of cases, but then you got questions of incest and your having sex with your kid. So that was how they used to do it before gay marriage.
Well, there went the monetization. Now moving on.
Folks, I gotta run because I have a stream coming up here. Probably the final pre-trial hearing of Donna Adelson.
Okay.
Yeah.
All right.
So I'm coming back, starting in a few minutes. So thank you for having me here. See you all. See you all next week. Hopefully.
All right.
Yeah. Later, brother.
Sounds good, man. Thank you, sir.
Bye bye.
All right. Let's talk about Bryan Kohberger. I think that was the case. I think that everybody was going to be
frustrating.
Everybody's going to be streaming, but they're very real questions. A lot of people are saying, well, wait a minute. They pretty much had what appeared to be a slam dunk case. Now, I don't know all the evidence. It appeared to be stronger than some people thought at the time. As time went on, more and more came out about it. I guess I'm going to ask someone question of is it possible that they moved off of the death penalty because of the two living witnesses who would have to testify and maybe could be seen as further victimized? I'm just trying to figure it out and throwing out possibilities.
There's a lot of reasons why they might. I mean, one of the biggest ones is why you offer a plea. It's done. We have a guaranteed outcome. And that's for a defendant. It's also for the prosecutor. You know, maybe a jury is going to say, yeah, it's a little weird. You guys sat around for like 8 hours, just the stench of dead bodies reeking through your house. And people were over there. We still don't know who was running around in the house during the 911 call. And a jury might say, yeah, wow, that really doesn't make any sense. And, you know, if a jury decides that doesn't make any sense and you get a hung jury, are you really willing to risk that? So, yeah, it's a valid way to cut a deal. It's done, it's over with, and it's out of the way.
And to Sean's point, I think a lot of people have been portraying this as a slam dunk conviction. Especially a lot of the crime channels, I noticed they seem to be like, oh, this is an easy conviction. And I'm like, I don't know that it's such a slam dunk. You have a pretty good case here. If you ask me, gun to my head, did he do it? I'd be like, yes. But I'm very far from believing that there's evidence beyond a reasonable doubt. You have one eyewitness who saw bushy eyebrows, and you have a knife sheath which has his DNA on it. Which
okay, hold on. Let's talk about that, because no, that is very compelling. By itself, you're right. Touch DNA, oh, that sucks. Okay, but let's add the other layers that do make that sheath pretty damn compelling.
Okay.
You have touch DNA on that knife sheath found under the victim through some kind of a scuffle. So, you know, how did your sheath get under the victim? That looks bad. Now, where it really starts to look bad is that, oh, we found out that you did buy a particular K-bar knife and a sheath. Oh, you bought it on Amazon. Well, okay. Hey, I buy stuff on Amazon. We all buy stuff on Amazon. But wait, there's more. We used a gift card to buy it on Amazon, so it didn't really, have a credit card tied to it. It's like, well, okay, we might use a gift card. It was a good time of season. Wait, I'm erasing my purchase history of my K-bar knife on Amazon. That looks absolutely totally normal, because, I just don't like to have my purchase records out there. They look bad. So I'm just saying, I think that, it's funny. You could say, oh yeah, touch DNA, it sucks. But those other factors do,
yes,
I think it more compelling.
And then they find your car torn apart and you're cleaning it. It's like, hey, we all do that.
Or we take plastic bags and we take all of our personal effects and we deposit in all the neighbors' trash cans along the street, and after washing them, this is very normal, absolute behavior.
Sure.
Okay, and before I defend this, I want to clarify here that if you ask me, I think Bryan Kohberger did it. Okay, I think he did it, but a defense counsel will likely make the following points. Yeah, can you really rule out beyond a reasonable doubt that he had some bushy eyebrow friend who he's driving past the place, and he's like, yeah, this is where those girls live who think they're superior to me, that they wouldn't even return my phone calls when I tried reaching out to them, and they snub me or whatever. And that his friend picks up his knife and went in there and did all these savage acts, came back out, and he's like, oh my God, and then he fled with him, and he's like, I don't want any evidence that would tie me to this crime. Can you do I think that happened? Absolutely not. But can I really say beyond a reasonable doubt that definitely did not happen? I don't know. I think if you're going to the high standard beyond a reasonable doubt, I think that it's, you can't really put him in there beyond the bushy eyebrows. You can have his knife in there, and it could be his friend picked up his knife that he had bought on Amazon, and then when he saw his friend come out looking like he did, and he's like, oh my God, you just did that.
Which friend is that now, Joe?
I'm just saying, can you rule out that there was another person with him in the car who actually went in there and did it? Can you rule that out, that didn't happen beyond a reasonable doubt? And if you can't, do I think that the state would win? I think they likely would win. But is it possible that if they present a theory like that would not help him at least get to a hung jury?
If I recall, in the 2 weeks before, they were trying to do the Sadidi defense or Saudi defense. Some other dude did it. And they came up with a supposed alibi for him. They know he happened to be over this thing. And Judge Luker said, that's no alibi. And they also put in, I think, 5 different names. I just interviewed Howard Bloom, who wrote the book on the Idaho murders, which is really good. That's going to be coming out next week if people want to check it out. Self-promotion. But the judge ruled, and this is literally 2 weeks before, sorry, no. These are bullshit claims with the other people, and disallowed it. And then that's when they came to the table. The defense was like, you know what? How about we make a plea deal?
Yeah, can I ask a question? Why are people upset? All right, so he was facing the death penalty. He pled guilty to the 4 first degrees and the burglary, right? So he's doing 4 life sentences murder, and plus 10 years, right? So it's like
10 years will get you.
And then, but generally in death penalty cases, it's either hey, plead guilty to the top counts and we'll take the death penalty off the table, and that's generally what happens if the evidence is overwhelming. And
well, I'm mad. I'm mad
so.
because I think the judge should have insisted on a full allocution. Because
thank you. That's where I am.
Well, the allocution you want.
And what about the gag order? And I want the gag order removed.
Yeah, okay. I'm like, look, if I'm the judge, I can reject a plea in the interest of justice. And I'm like, people have the right to know what happened. So I'm like, one of two things is going to happen. Either you're going to tell us what happened, or the evidence is going to tell us what happened. So pick. As like, if that's worth something to me, but this judge didn't do it because he's a pansy.
Hold on, from my understanding, hold on. From my understanding, the sentencing is coming up, and Howard Bloom did say that the judge may require that, or he may have to answer specific questions during sentencing. So I don't want to go so far as to say that that'll never happen, but
not a chance that he's going to be required to answer pleas during sentencing.
Did you stab blah 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 to the point where they were dead? Yes. Did you? Were you at this play? Like they'll go through the facts of the case.
No, they went through the legal bare minimum. They met their legal bare minimum sufficiency for the plea. But I'm like, I want more. Give me more.
I'm just like, we want him to get the death penalty, but life in prison without the possibility of parole and 10 years on top of that is not enough. I don't know what people want. Like,
well, at least tell them
that's as good as you're going to get.
Tell the family what the hell happened.
Yeah, that's what
I would say that.
You know what? Because you have people running around right now saying it was a setup. You know that, right? There are actually people out there saying, oh, they didn't prove anything. Oh, it was that. Oh, he was entrapped. Oh, it was bullshit. Oh, he's just doing it. It's like, just state what the hell happened. Now, I do fear the other side of it. I know, like Dennis Rader, I don't know if you guys saw that, the BTK killer, but he went and literally during his pleading or whatever, he said, I went in there, I picked the lock, I did this or that, whatever. He gave literally a timeline of what he did, when he did it, and what happened. And I don't think that it's unfair to the families, et cetera, to have the opportunity for him to say, I did this. This is that. Now the why, I get it. He could be lying anyway, but at least give a narrative of what the hell happened. And then whatever. Then
what if his narrative is complete BS? How we know his narrative is true?
I mean, that's why you have evidence, Joe. You have evidence. And by the way, and if his narrative is complete BS, then is there a possibility that you do have the wrong guy? Again, I like the narrative. But you're going to plead guilty. No. This is common. If you plead guilty, you have to, you write out a confession. I did this and this and this. And then later on, sometimes the confessions are held up. It's like, you know what? This guy didn't do it. Even what he said doesn't make sense.
I'll tell you how you ensure that it's true. Once he gives his full allocution and recites everything in court, once you do that, you turn over to the prosecutor and say, hey, Mr. Prosecutor, is everything he said true based on your understanding of the evidence? And if he says no, I'll be like, okay, I reject it because it's not true. Oh. Lol.
Yeah, that makes sense.
That's how you ensure it.
Yeah, well, I don't see the difference between life in prison. The family gets justice, everything. I understand that it's like
the families don't feel like it.
The total outrage just seems misplaced to me.
But the families would, the one guy who's upset basically wants to go beat him to death with an axe handle in the courtyard of the courthouse. Like, for some people, and I've dealt with this as a prosecutor. You would be the victim of your car getting stolen, Eric, and you call me and you'd be like, I want that guy going to prison for 20 years. And I'm like, he's looking at 18 months and he's going to get probation anyway. Like, no, like you may want something, but it's just not practically feasible. So
yeah,
the victim's being upset.
Okay. So tell me why a gag order has to stay.
I don't. I would at this point. I don't think it should.
I mean, through the
it
sentencing, I
should.
would understand, but there's a gag order beyond that. I won't really
Why,
understand.
why are the Epstein files still? You know, that
Yeah,
case
no,
has
I
been
agree.
over.
Oh, thank you. That's the last topic of the
Epstein
day.
Files. That's
Yeah,
why there
right,
are no
so-
Epstein files.
Yeah,
There's no
no
list, and there's no files, and there's nothing to see here. What are you
Oh, here we
talking
go.
about?
Yeah,
Oh, no, this is the segue. You did it, Nate. You segued.
Yeah.
Next subject,
All right,
the
there
Epstein
we-
files.
I was going to ask a philosophical question on Kohberger before we got to Epstein, and that
All
was
right.
And that's a
Make it
good thing
fast.
for drop a comment below if you're watching after. Drop a comment below. Do you think that the feelings of the family about how justice should be imparted, do you think that that should be a factor that should be considered by the court or the prosecutor, either of them or both, or that they or do you think that this is the state's case and that we should how they feel about it is really ultimately irrelevant?
Well, I'll tell you this: when I was
Oh, a
DA
factor for sure.
When I was a DA in the Bronx, they made it very clear: you are representing the families. You are not representing the victims. You are representing the people of the state of New York. And the best outcome is a justice outcome for the people of the state of New York. Now, the families may want something different, but
Yeah.
I don't represent them.
Hold on, but it is a factor. Now,
Yes,
you
it's a factor.
said
It's sentencing. It's a factor
which-
in what we do, but it has no relevance to if I
Yes.
come to a plea agreement, whatever. I can say, oh, I wish we could do this. I wish we could do that. But it's totally the decision of the prosecutor's office with how far to go. Yes, it'll influence me. I want to make them happy, but in most cases, I just can't, and we're going to do what we need to do. So
and my take on this is I think that before you have a conviction, it should not be a factor at all. Once we have a conviction and then we establish guilt, because you have to get to that conviction. Once we have a conviction established, at that point, what they feel, now we can say verifiably, this is the guy who did it, and you're the victim. You're a direct victim of what this guy did. At that point, now I think that their feelings should be taken to account.
I'll push on that really hard because
That's-
to say that there's nothing,
Nothing.
that's bullshit. Then it's like, yeah, you know what? I just don't feel like prosecuting this week. Well, wait a minute. He just, did these crimes. Well, I don't give a damn. I just don't like it. No, there should be a factor. Is there further danger to the people? Are they a further danger to those around them? Whether you prosecute, just to say that there's no factor.
New York. That's the people of the
But,
state of New York.
but you know what? Those families are the people of state New York, right? Those people are in the community.
I'm
The
not
families
rectifying
themselves
them.
are part of that. So
I'm not trying to rectify. I'm not trying
no.
to appease them and rectify them. I'm trying
it's
to.
not appeasement. It's a factor, though.
yeah,
To say it's not a
would give you
factor is
I
just
think
rubbish.
so. My position is, and I think it's consistent with the way we tend to do things, is because we ask for their input after there's a conviction. Before the sentencing, we ask for them to come up and make statements. Beforehand, we don't. And I think that that's my position here is consistent, and it's also philosophically moral, because ultimately this prosecutor has to be free to go and get and secure that conviction as neatly as possible without feeling like, oh, I owe it to John Smith, who lost a brother or lost a child, to try and get this particular outcome. I think at that point now you're diverting from trying to represent the will of the entire people of the state, and that's why I think after conviction it makes sense. Beforehand, my position is I don't think it should be a factor. But that's just an opinion. I'm not telling you.
Right. Well, that's why we have a comment section, because I definitely wanted to fill up and everybody say there, but I'm going to disagree because it is a factor, and I didn't say it's the only factor. I didn't even say it's a majority factor, but it is always a consideration. And I think a factor or consideration should take place throughout the entire case, if you will, just like there are mitigating circumstances. Last time I checked, right? There are things that may weigh on the scale one way or another.
Mitigating circumstances are in sentencing. They're not in conviction.
But it also is in charging too.
No,
bullshit. Nate, you were a prosecutor, and you will look at something, and if you see particular mitigating circumstances, it may help your charging decision. Correct?
Which you're mixing up is the legal justifications for like mitigating factors, and those are legal things that the prosecutors would have to actually prove in a case. Then versus a factor in determining how hard I go at this defendant. Right? The prosecutors are supposed to seek justice above all. That's why they don't represent individual victims. They represent the community as a whole. And like you said earlier, well, they are part of the community, but you're not representing them. You're representing the community as a whole. So you're looking for justice for that community. So yes, but
you're also looking for the justice for the defendant.
Well, hold
on.
Well, yes, but so exactly. But for the factor, as a factor, it is essentially a minuscule factor. And yes, personally, I want to help them but That is not my concern. As Joe said, during the liability phase or the criminal phase, we're trying to find out if they did it or not. Mine is to get justice. But then after I secure that conviction based on the evidence, then that's when they step in and they become a greater factor in determining how much sentence. That's what they go told the judge, how this hurt and all that stuff. So before that, it's all me. It's all me. I am the agent. I am representing the people. And then after that, then that's when the families come in and we want them to give their opinion because they're the ones who've been harmed by this criminal act that we've now proven.
Again, and that's why I'm saying my mitigating factor, all that I think is still relevant. And I know I'm hard-headed on, but again, when you're making a charging decision, for example, with the person, what were the circumstances at the time that this happened? And depending on said circumstances, it depends on how hard you go, because you could say, oh, he killed him, that's it. Or you can say, oh, there's questionable, factors or whatever. I think that you should never say that, oh, something is never a factor. I think that's irresponsible. Well, we'll move on.
What about Pam Bondi's opinion as to whether or not there's a list?
Yeah, well, that's what we're going to. Is the list.
Have you guys seen what just came out with what's his name?
Dershowitz?
Yeah, Dershowitz says it's absolute list. He knows who's on the list. He's seen the list. He like there is a list. He was on the list.
But there are as many people who have disparate opinions about whether to believe Dersh as there are whether there's a list and what it really means for there to be a list.
Here's the problems that I'm having. And look, the whole thing's ugly. And the person who made this whole situation worse than it even had to be already, well, there's two people. First off, Pam Bondi has been an utter disaster with this situation, going all the way back to February with the whole "it's on my desk" and the binders that she gave all the influencers are walking out. She turned this into a spectacle back then. Now, the second person who I am blaming for the firestorm right now is Donald J. Trump. In his cabinet meeting, when he acted like the most idiotic, guilty party ever, the way he said, why are we talking about his little tantrum is something that in the behavior world, my friends at the behavior panel like to call chaff and redirect. That is what are we even talking about? It's like, you know what, the memo was released yesterday. Don't tell me this isn't current news. You are acting like somebody, you just got nailed with a little problem here and you are squawking. And I feel like he is responsible for this going up even further. What say all of you?
I have a lot of opinions on this, but I want to let others weigh in first.
Okay, well, let me just lay out the timeline. Well, so I'll give my opinion, and then I'll lay out the timeline on why I think this is my opinion. Is this? I think the list exists. I think Trump and I think Dershowitz both know that list exists, and I'll tell you exactly why. When Epstein was first arrested back in 2008, it was Alex Acosta then they gave him the sweetheart deal where he gets weekend jail, right? That was the first thing. His lawyer in that case, who knew all the evidence and saw it, was Alan Dershowitz. Alan Dershowitz was his lawyer. He was doing all of it, and he got him that sweetheart deal. Now, Alan Dershowitz is a great attorney. Then he got sweetheart deal, he's gone. 2019, he's arrested again. Who's president when he's arrested? Donald J. Trump. It's his attorney general, his DOJ, everything. He's privy to all of that information. He's privy to any list, any documents, any evidence. He knows it all, right? He's president at the time. He's president when he died. Donald Trump has all of the evidence. He then loses, or the election is stolen, to Joe Biden. So he's out. When he's running again to become president, part of his campaign is, I'm releasing the Epstein files. They're hiding this stuff. Here's the stuff. He went on Lex Friedman. Yeah, there's people on the list. This list, right? He's saying list. Then he gets reelected. Who does he hire? He hires Kash Patel, who's also been out there saying, there's a list. He didn't kill himself. Then who's he hired for deputy director? He hires Dan Bongino. There's a list. There's all this stuff. Then who's he hired to be their boss? It's Pam Bondi, who comes out. It's a list. I have the list. It's all my desk. List. We're gonna release the list. Then all of a sudden, there's no list. Yeah. That is the reason. So I believe either he's been lying for the past 8 or something years about there being a list from when he was there, when he saw all the evidence and all this. So now all of a sudden there's no list. And I will also say this: the reason why I believe Dersh is telling the truth, because he was the man's lawyer, and Dersh has been saying there's a list ever since back, I think 5 or 6 after Epstein died. He just I can't, because most people don't realize Dersh was actually accused by one of the people of being on, having the relations.
Giuffre. Virginia Giuffre.
So and then she said, then she
Who's
backtracked and said it
passed away
wasn't.
recently, by the way.
So he got out of it. And I'm also going to say this: if people don't believe there's some type of list, I think you're being naive, because Pam Bondi, if just listen to what they're saying, there's over 200 victims. They know who got massages. Matter of fact, there's a picture of Bill Clinton actually getting a massage by one of the masseuses. They know who went to the island. They got the flight logs. You know who was at the island. You can just ask the live masseuses, who did you give massages to, right? So they know who the people are. And they're sitting there telling you that we know these people. Got to make sure we keep this monetized. We have these people who we know, the live victims, who know who they had these interactions with. We're not going to go after the people who did this to them. We're just going to pretend that these people don't exist. Like, really, are we at that point? We have live victims who can say, I gave this guy a massage at the island, right? It's not like they don't know who these people are. So to say that there's no incriminating list or there's no incriminating for any third parties, if you believe that, there's a bridge in New York I can sell you. It's called the Brooklyn Bridge, and I got $1, and it's only going for $1.
And I'm sorry, guys, but Nate, more importantly, all the staff that helped, somebody in that staff had to have committed a crime. Because it wasn't just like, oh, I'm the guy who mows the grass, and I did, somebody had to have known. If we're gonna go with the theory, they were just trafficking children to themselves. Someone else had to be in on it or know about it and help facilitate it. They couldn't just like sneak this in everywhere. It's like, oh wow, she's having business meetings with a bunch of people who look really young, but I guess they're reverse progeria or something. Like there's no reasonable explanation for that. So yes. Either the clients, or really, if we're going to buy this theory, other people were involved. Yes, those people. Why aren't we going after them?
Now there is one issue.
Andrew, he paid $12 million.
That too.
Right?
By the way, Andrew's free now, though. By the way, he's running around since the case has been dropped. He's travel. All the restrictions are gone. By the way, one thing I do want to point out, though, and this is going to push it the other way slightly, is when they talk about lists, it is an odd thing. A lot of people have been talking about the black book of Ghislaine Maxwell. Now, that's a harder equation because, for example, I have a lot of phone numbers in my cell phone, okay? A lot of numbers. And now everybody I have a number for is necessarily a friend or whatever. It could be a one-time acquaintance. It could be buying a used car or whatever it is. When you have people like Ghislaine Maxwell and Jeffrey Epstein who raise a lot of money for a lot of people, there's a lot of names and a lot of phone numbers that are potentially in address books or phone books. And I think it's really important to separate. Just because there's a contact with that person doesn't mean that person is guilty of a crime. And obviously, I think it's important to point that out.
But I want to be very clear, though. Are we saying we don't know who the live victims are? There's over 200 live victims. We know the live. Could we ask those live victims, who did you do this with? You show them pictures. Here the pictures, right? And they can say, yes, I did it with them when I was 15 or 16 years old. And I'm assuming the FBI, because they remember with Pam Bondi, she set out that binder full of nothing. There was a list of masseuses right inside that it was all redacted. These are all the people. So they know who these child people are.
Yeah. Well, there should already be questioning. The FBI or whomever should have already interviewed said witnesses, and it should be in the record. I mean, there's supposed to be a couple of pallets of information.
They don't need a black book. You don't need a black book. You literally have the live victims. You literally have the flight logs. You have everything there to go after these particular people.
Yeah.
You have more here than you had.
But there was no information discovered that would lead to the prosecution of any additional suspects.
Remember with the FBI, it's all done on 302.
Clear too. He had the whole house wired up for sound and tape. Like the whole thing was being taped.
Those tapes didn't reveal anything. No additional. The flight logs revealed nothing. No additional people.
She said they had pallets of tapes. He was taping everything.
No, the pallets of tapes just showed cooking. It just showed him doing cooking. That's it.
Are we really at that point where it's saying this? There's no way to find out who these people are.
Yeah. Well, that hostage video that Patel and Bongino filmed with, I think it was Fox News, where they looked in the camera, be like, "There's no evidence. There's nothing."
Well, Laura Loomer just
It's all
came out
fine.
today.
Everything is great.
Laura Loomer
Oh,
just came out
God,
today, and you got to
her
take
name.
everything with Laura. You got to be careful with
Yeah.
Laura on some of the stuff. But
Oh, geez.
Laura's claiming that Bongino and Patel are ballistic. The Bongino is taking personal time off from the FBI because he feels betrayed by Bondi or something, and there are questions whether he will even remain at the FBI or he may be quitting over this again. Check the source.
Why would he
I'm
quit?
not
He
gonna
looked straight. He looked straight into the camera and said, "There's nothing here." I've looked at. He
No,
said,
no, it's the
looking straight
memo.
at the camera. Oh.
That memo was unsigned and leaked by Axios. Everything we're talking about is in the Axios memo. He did not say there's nothing to see here. He said that the guy took himself out, according to what he had seen.
That
He
is
didn't say
not
there
what
was
he said in that
no.
interview. He looked
Okay,
straight
what
in
he
the camera and said he looked at the entire file and he was confident that he killed himself and all the rest of it. It's there's nothing to see
What did
here.
he say about the cases? He didn't
But
say
what
that there was
about-
no
what
other people or anything else. Make
He
sure
didn't-
that
he didn't-
parsing that? Okay, fair.
No. So that's important parsing though, because
Yeah, it is.
reality is and in the timeline there, and the timeline that Nate provided was excellent, but in that timeline there was this devolution from and the way that things have unfolded over the last 6 months, in case we lost track here, is Pam Bondi said, "Yeah, we got this. I'm working on my file." She had a release, and that release turned that everyone was all excited. "Oh, we got the list here. We got this stuff here." And that turned out to be a joke, which was humiliating to Bondi and the administration, because it was all information that everyone had 3 years ago. And all of a sudden, this is supposed to be the big transparent reveal, and that was humiliating. Then we had Dan Bongino and Kash Patel in that hostage video saying he killed himself. "You don't question me. I worked for the prosecutor. I worked for the DA's office. I know when someone is self-deletion and when they're not. And this was a self-deletion." What?
Can we use the word self-deletion to try to keep this monetized?
That's what I said, self-deletion.
Yeah.
No, but you said the other thing.
Okay, yeah.
I appreciate it.
I apologize for that. So he said, that this was definitely a self-deletion, and Dan Bongino looked as if he was sweating bullets, and this.
But
none
it's
of this,
all about his state and what happened ultimately to Epstein in the cell.
Not
to
about
Epstein it had nothing about the case that I know of, and that's why I was parsing, because I think they're two different things.
Not whether during his life he was providing this depraved service for third parties. And that's really the key thing that a lot of us care about here. Not just whether he was individually, we all can agree that he was individually a sicko, but the question is whether he was actually providing this service. And the questions that abound here are so plentiful. If you want to try and take the position this was his own individual activity, and there's no one else involved here. So in that case, there's so many questions. How did he amass this great fortune? How did, how is it that he has this vast wealth, and how does he have thousands of victims? And
how did he get hired for that school by a certain attorney general's father? Oh my God. Yeah. We're just,
there's so
and how did he get the plea deal? The plea deal is the key thing here. Why would they allow it to go on for as long as they did, all the way from the early to mid 90s for a decade, for 12 years at least, till 19
and how did he become an
2007
informant after it?
And the references that Acosta's attorney made to, as far as that we heard conversation back in 2007, 2008 about how he was connected to intelligence agencies. So I think that for people to just assume that he's connected to intelligence agencies and that's why they're letting him do this individually for his own individual tastes, that strains credulity. It doesn't seem to make any sense at all. On the other hand,
just a correction, in his first case, the U.S. attorney said that he was connected to some intelligence agencies. The U.S. attorney on the case,
which means the FBI had files.
So it's like,
he became
making that up.
He was an FBI informant as well. After he was convicted and he got the deal, he was an FBI informant.
So nobody just made that up,
right? And if you want to try and give Bondi and even I guess Trump the benefit of the doubt here, it's very possible, and if not, you would think likely, that seeing as how the Biden administration certainly seemed to have no inclination towards prosecuting any of the treasure trove of information that should have been in their files after, when they went through all his stuff, since they seem to, it's very likely that whatever was in the FBI's possession is no longer there. And there's a big file called the Epstein file, which you click on any of those files and it says, 404 error, and that there's nothing to be found. And then when you want to give Bondi again the benefit of the doubt, and I'm not saying we should, I'm just saying if someone wants to give the benefit of the doubt, you can say, yeah, she knew that there an opportunity now to start going through those files. She had not started going through them. She expected to find stuff there. And when she started going through them, what she saw was nothing that was remotely incriminating to third parties. And now they don't feel they have anything that they can prosecute. But still, to that, Nate makes a great point. Why can't you just question these people and recreate your own new file? You have your whole freaking FBI and DOJ. Why can't you start recreating everything if you're genuinely interested in prosecuting this? And you seem to have given up on trying to do that when you come out there and say, well, we have nothing, but if something falls in our lap sometime in the future, in that case, we'll be prosecuting. And that is something that most of MAGA and people on the right who supported Trump cannot abide by. And that's the frustration. That's why people are talking about making protests and screaming about this day and night for the last week on X, because it seems as if they're just throwing up their hands saying, well, nothing left, story's over. And then Trump comes out and says that. Trump comes out and makes that statement. Now, if you understand how Trump thinks, and I think I do, it's very possible if you want to try and defend Trump and in that press briefing, which I'm not going to kid you, that was a gut punch what he said. I personally felt it, as millions of others felt. That was a gut punch what he said there. You want to try and understand how Trump thinks and how he talks, you can look at it and say, okay, in that moment where he's sitting here dealing with Texas, dealing with these things that they're trying to do, he wouldn't want to be distracted about anything, and he felt that this was a distraction, and he was just sort of knee-jerk reacting. I'm not excusing what he did. I'm not saying
no, he does, because he answers
completely
everything.
Inexcusable. It was inexcusable. I just think that that's likely the motivation that he had, rather than recognizing that his very answer makes him look guiltier than anything else he could have said or done. His very answer made him look terrible. Objectively, it made him look terrible. It made him look as if he's scared of what's in that file. And
he
it's
looks
hard.
terrible, Joe, because of his past behavior as well.
100%.
Trump answers any damn question. I mean, they throw out the most ridiculous questions to him all the time, and he's always very comfortable answering them. But that particular time, just this one particular time, all of a sudden, it was like, boom, he just starts throwing out all these players. So that's part of the problem, too.
But you can understand, if you want to try and give him the benefit of the doubt, in the context that we're talking about 100 dead children in Texas, that he's like, now you want to start talking about this when we're dealing with, our rescue efforts in Texas and things that are happening here. Like this is what you want to talk about. I'm talking about the efforts we're trying to do here to save people, and you want to fixate on something that happened a decade ago.
But he was also talking about victories in the same thing, too. So he was like,
right.
Oh, here's some happy stuff. Here's some bad stuff. Okay, it was all mixed up. So, I know people are trying to do that, but no.
Yes, and even more to that point, as far as his lack of understanding as to how much of a gut punch this was to MAGA, and it was a huge gut punch, is that he also, even the very day that they came out and made their statements, he came out and said what a wonderful job Pam Bondi and the DOJ are doing. And it's just like, everyone who read that, who follows him on True Social, was just like, are you kidding? Are you a joke? Like, what the hell are you talking about? That's insane. Do you come out with that today, of all days, that you're going to say what a wonderful job the prosecution and the DOJ is doing here and the FBI are doing here, when they just came out today and basically said we're giving up on this Epstein thing altogether? That was basically seemed to be ignoring how much of an issue this is. And I do think that this will, if they do not correct this, and frankly, I'm doubtful that they will. If they do not correct this, this will be a stain on how he is remembered forever. If they think that next week news cycle is just going to knock this off and people will forget about this, I do not think that's reality.
They're meeting on this. They're meeting on this. They got to be war gaming on this. It was a big fumble, and my understanding is that it's really knocking Trump's numbers down, and that even though I think I agree with Trump on the merits, not on the way he handled it, that it has taken a preposterously disproportional place in the psyche of conservatives, especially on the internet, compared to what's really going on.
It's in his base directly.
it's because the Democrats could not have come up with a better op, and I don't think they did. I don't think.
No, that's why they're sitting there quietly, just
Yeah.
watching and eating
There you go.
popcorn because it's
Exactly.
perfect for them. I think that Trump's best chance, or you guys let me know, but Tom Fenton and Judicial Watch have FOIAs in there like crazy. The answer could be start releasing the stuff to their FOIAs, so that way they can kind of just let it all get out there, and then they could just say, look, it got released on those FOIAs. Leave us alone. We said we didn't want to talk about it, and we're taking care of it on the back end. That's the best I can think of, and even that's not great. What do you guys
They're not
think?
going to release anything on FOIA. They're going to invoke national security.
Yeah, they're not releasing none of that.
Well, then it'll look even worse. Then it's never going to go away.
That's
If
not
they
gonna
don't find a way to,
they're going to have to
even
do
if they
better.
redact the hell out of it.
They walked into this. It's an unforced error, or maybe it was a forced error. Maybe that's something that they believe that they had to deal with to get elected. But it's a bed that they've made. They've got to lie in it.
Perhaps some
and Bondi's got to go.
And the reason
She should never have been there.
A client call coming up at 1:30.
Oh, thank you so much.
Ron, real quick before you go, you got 2 minutes. I noticed you said something like the notion of what Eric just said, that Bondi must go is insane. And you made a comment to that effect on, I thought I saw
earlier in the week on
earlier
X,
in the
yeah.
week. Yeah. So my question is, are you still of that opinion, and where are you
Let me
on
make
that?
it very clear what I said. What I said was, it's insane. What is insane is that almost everyone on social media, which does not mean almost everyone in the world by a long shot, much less everyone in America, but this obsession with Epstein as the only criterion by which we would judge Pam Bondi's performance, while ignoring the transformation that's taking place in the Justice Department, the arrests that are taking place on child trafficking, in fact, throughout the Southwest, and the lawfare victories and how they have so effectively almost run the table at the appellate level and at the Supreme Court level on the lawfare stuff. Huge. But on but almost everything having to do with the FBI has been a real disappointment. But to say that that's the only, therefore Pam Bondi must go, I think
Pam Bondi must go, not just just counting all other jobs, but there is a what have you done for me lately? And if you have done something to such a degree that you're threatening the entire legacy of your boss by bringing out everything and drumming up and setting the expectations, all that. No, in February, she made this bed. Her little Fox appearances, all that.
The binder thing, that was an absolutely self-imposed
Fiasco.
Fiasco is the only possible word for it, and that's what she gets for not following me back. Guys, it's been great after I stood at her side in Philadelphia in 2020. Guys, have a great weekend.
Thanks, Ron.
Brother.
Thank
Hi,
you.
Ron.
I want to explain to you all why. I understand what Ron is saying, that this does preoccupy, his base and MAGA specifically so deeply, and more perhaps than it should from an objective perspective. But then I'm going to explain to you subjectively why this is such a big thing to MAGA, in my opinion.
They made it a big deal.
They're the ones that made
Yes.
it. Yeah.
They did make this a big deal, and you can talk about how they could arrest 100,000 child traffickers, but they're all no names. And the big thing that we've been fighting about, what has MAGA been about? We want to get rid of the deep state. We want to feel that our political leaders are actually doing things designed to help the American public, and they care about protecting us and taking on the role that we feel has long since been abandoned over the last several decades, and greater percentage of lack of complete discarding of the interests of the American public over the last 10 to 20 years. So now is this whole thing was supposed to be the rise, that we're overthrowing the deep state, that we're coming out there and we're now going to fix things. The reason we're here now, the reason we're electing Trump, is because this is now a statement that we are done with the deep state, and that we are actually going to be fighting for what's fair and truthful and accountable, and have people held accountable irrespective of who they are. And this was basically, who do we put in that position? We put and Cash and Dan Bongino, two people who 6 months ago would have been deemed ranked in the top 10 of patriots of this country as far as their voice and the positions that they took. And for these two people specifically to come out there and make this statement that they're swallowing and selling us what we all believe to be the deep state talking, and they're trying to sell it to us, the very people who we've trusted for so long and made such a big deal about this, for them to come out and now seemingly become puppets of the deep state makes us feel a certain hopelessness that I have no idea how we ever can fix this problem. If you can poison their mindset, if you can poison their perspectives, and you can basically have them come out and say, hey, I'm going to just tell you what the deep state wants me to tell you. We're sitting there and we're left thinking, are they compromised? How scary is this? That the very cleanup people that we were looking for can now so easily be turned on an issue that is the most important possible issue, protecting the innocent children, making sure that the lives are not being destroyed, and that you can be turned on this issue to help protect elites from prosecution accountability when they have terrorized, traumatized, and destroyed the lives of countless children, and that you're just gonna be like, well, deep state wants me to say this, so I'm gonna now be selling this to you, feels like an utter betrayal. And that is why this is going to stain him forever, because the very people who have been carrying the banner for Donald Trump, they are the ones who are least likely to be tolerant of this type of whitewashing on behalf of elitists who have conducted the most nefarious type of activities imaginable. That's why this betrayal feels so terrible. That's why I don't think that this is going away unless they take steps to say, we effed up. And frankly, unfortunately, the MO of Donald Trump and his team has never been to say we effed up. And without that, I don't know how this gets repaired. And it's very, very unfortunate because it was an unforced error.
I agree, Joe. And can we point out one parallel, and then we're going to wrap up really quickly. The same week that this happened with the Epstein files, you have the doctor of Joe Biden pleading the fifth on whether the president. So you're literally both administrations, same week. It's kind of like in the news, a reminder of, is this the new boss, same as the old boss? Is the deep state ascendant again? Is the deep state coming back and just taking control? And I think a lot of people looking at the full scope of the news can't help but go, here we freaking go again. Everything is the same, but go.
Can I add one thing about this, Dan Bun? They released, so Dan Bongino and Kash Patel said, we saw the video, it was clear, he blanked himself. They released that 10 hours of video with the 1 minute missing and on all that.
Yeah,
and it wasn't really up the door. Did that video conclusively prove that what they said happened? Matter of fact, it was so unconclusive that Bondi the next day in the cabinet meeting said, yeah, we know it wasn't conclusive, but the minute missing and all that stuff. But Dan Bongino and Kash Patel went on Fox News and said that they saw the video, and that video absolutely proved what happened to be true. Now we've all seen it. So obviously, I think people don't realize the deep state is extremely powerful. It's so powerful that when you get in, you become the deep state. That's what's happening. They're in there. They got all that facts. They got all the evidence, and now they've become the deep state because they're protecting obviously other things. We're all of us who are lawyers. No, this is if you were a prosecutor, this is an easy case to develop. You got the witnesses, you got all the stuff, you got everything. You got unless they destroyed the videos and stuff. But why aren't they developing it? Because there's something the deep state doesn't want it to be developed. It didn't want it to be developed under Biden. It didn't want it to be developed under Trump. It doesn't want it out there. So no matter what happens, we're never going to see this evidence because that's the way it's played. And Dan Bongino, who may resign, and Kash Patel are now a part of the deep state. Take it or not, that's what's happening.
All right. Well, Nate, while you've got the floor, what do you have coming up?
So just my regular videos. I know I haven't been producing as many videos as I usually do. So people have been, what more videos? So I'm going to be producing. I'm going to be changing my style up. So I got a whole bunch of stuff coming up. I got another Epstein one detailing like every single point and why I believe what I believe. And I'm going to be trying some new stuff. I'm going to be trying like a live stream channel and all that stuff. And we're working with AI to really, really, really see if we can focus in on stuff. For those of you who don't know, YouTube has now changed a lot of its policies. So now those AI generated videos on YouTube have seemingly become a problem. So now no more AI generated content will not be monetized on YouTube.
You're not being quite accurate. But
That's what they said, right? The AI generated
no,
content.
no. They
Faceless,
said
right?
it's not faceless. It's crap content, essentially spam content. And I'll give you an example. There's a rash going around of Reddit stories where people will go find a Reddit story and then they put an AI voice on it and then just spit text up on the screen and then they put it out there. And I've seen them get literally hundreds of thousands of views. That's what's being attacked. You can make a video 100% AI without a face, but if it is a constructive effort, and by the way, while we're at it, I'm going to pitch my own thing anyway. This is an example. This is 100% AI except for my voice. I used AI to generate in 1920. One man stood up. Let me mute this. To generate animation. This is constructively creating actual content. Script is written. I'm doing my own voiceover, things like that. This is 100% okay with YouTube at this point. So I think it's important to consider. And if you guys want to check this out, I do appreciate it. It's in the pinned comment. These
are really good too. I even sent some of these to my kids. They're the history piece on it was really good. So
thank you. Yeah, their shorts are all, like each one of these is around 2 minutes, a little over, a little under 2 minutes. It'll be 3 minutes or under. It's YouTube shorts, but the point is that you can use AI. That's not a problem. You can't just make spam or duplicative or reproduced effort, like just making the same video 50 times and then spitting it up there and then seeing which title hits and things like that.
They said that they re-uploaded content they want to stop monetizing too.
Right. So I mean, just to be clear, because that would be a really, really, really difficult problem.
Yeah, I was overly broad. But that's what we do. And obviously we all are using AI to do various stuff. But that's what I got coming up. And I'm praying Tiffany Hinyard is finally arrested, because I know that's going to be like a bomb. Oh my God. But it's like, it's one of those things where what's taking so long? Who knows? So
it takes time though. I mean, with these cases, you guys are, Nate, you're a prosecutor. I know that everybody is bitching at Bondi, everybody else about never prosecuting anybody, but doesn't it take a while to run a case together, put it in a grand jury, get everything in line if you want to actually prosecute them? And then if it's a financial case, there's a lot of complexity on gathering every piece of financial information, blah, 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 blah.
Well, I would say this. When you're talking about these type of cases of assaults with minors, there's generally no statute of limitations, but some states did, but now generally there's no statute of limitations for trafficking of minors. And we're also talking about live victims, and we're talking about flight logs. We're talking about, I believe
Hinyard is what I'm talking about.
Oh, Hinyard.
It's very complex with the financials and everything.
Yeah, with Hinyard, I think it may be more a little, because, and the feds like to come in with 100% like proof, like, to get their 99% conviction rate, except when it comes to Diddy. It didn't work out. But that's what they want to do. So it may be. But I would say this, in the Hinyard case, this wasn't really some master genius plan. She was sloppy. So I think they could. I think this is an easy case. But again, they may be dotting their T's and crossing their I's. But right now, I'm starting to have less hope that she's even going to get indicted. But we'll see.
Joe.
Yeah, if you ever noticed when I talk at the end here, I usually say, yeah, same old. And today I'm not saying that, because I actually have 2 new changes that are coming to my channel that I wanted to make you all aware of. First and foremost is God bless Nate, because he's been working with me and helping me try to actually produce videos as opposed to just live streaming. And I'm hopeful to start getting that out, where I'm producing content on a regular basis outside of live streams, but actually standalone videos that I'm figuring out the process here. And yeah, so I'm hopeful too that you'll see some of that. But the other change I want to let you all know about is I've regularly been streaming for the last 3 years, starting around 10 p.m. Eastern, and I'm probably going to be moving that up earlier in the evening to around 8 p.m. That's what I'm looking at, trying that. And like next week, I plan on trying that out. So if you're not a late night owl, I'm probably going to be, I'm more likely to be fitting into your time parameters there of actually streaming, probably start around 8 p.m. Eastern. So be on the lookout for that. And if my takes are something that you think you love or despise, either way, make sure you check it out. Good logic. There you go.
Awesome, Joe. Let me know. I can't help you on Fridays because that's one of our shows. But on
I'm
Tuesdays,
never
I'll
on
know.
Fridays. I still won't be on Fridays.
No, I know that. That's what I was saying. I might be able to do redirects to you on Tuesdays. That
Awesome.
might help.
That'd be great. Thank you.
Kurt, what do you have coming up?
Yeah, so I've been transitioning to edited videos, trying to do a little bit more like Nate's style for edited
Or Nate.
videos.
Nate's our
What did I say?
benefactor.
Did I
Go
say
on.
something else other than Nate?
No. He would say he was making fun.
No, I was saying Joe was just complimenting Nate, saying Nate's helping me out, and I know Nate helps
He
me
is.
out. And then
He's
you're
the
talking about that.
master.
Nate's actually
helping all of us.
Nate's actually my friend. We actually meet in person usually once a week. We hang out. We go to
I'm
the
your
mall
friend
together
too. What is
sometimes.
that?
When was the last time we went to the mall and got sundaes, Joe?
Oh my!
I'm sorry. It's not you. It's me.
Anyways, so I've been doing edited videos, and of course, related to our present topic, my video that I've scripted for today's stream is about Epstein. Of course, it is. And so after I go to the gym, I will record and edit that and probably post it at 5 p.m. So I'm trying to post edited story basically every single day, and so that's what we're doing.
All right. Well, thank you. And I try to not have too many asks, so I'm just going to stick with the one that I have. If you guys like history and you have like 2 minutes, check out one of the shorts. This is a concept that I've wanted to do my entire life. It's called History in Between. I've always been fascinated about the fact that we always go, oh, the Civil War happened, and then World War I happened. Well, what the hell happened in the, from 1865 to 1913, 14? What happened in between? There's so much history in between, and there are events that drive things forward that I think are fascinating. That story that I was just pulling up, that clip, is about the Matewan massacre, which was in West Virginia. You had a sheriff in a shootout. 10 people died, literally, including the mayor, in the shootout. The next year, that police chief was shot down on the court steps because they were trying to prosecute him again. That turned into the Coal Wars. The Battle of Blair Mountain, which involved over 10,000 miners fully armed with World War I gear, going up, trying to advance. They had civilian aircraft dropping bombs and poison gas on all the people. It is the largest labor dispute, riot, and the biggest battle on American soil since the Civil War. So, and I'm guessing, how many of you have heard of it? In the room. Kurt, you heard of it? Nate?
I don't think so.
Joe?
Well, I heard of you because you told me about it, but no.
Right. Okay. Well, that was a cheat,
Yeah.
but
I need
Anyway.
to now I know I need to check it out. And
okay.
I
Well,
will.
there you go. And it gives you, 2 minutes. Will tell you the first part, and then I'll be doing the second one. This is the second part. It's just going to be full of those. It's helping me learn how to.
And what channel is
create-
that again? Which
It's
channel?
called History in Between. It's actually
History
the
in
pinned
Between.
comment. And I also have it in the description. Those who are watching later, if you want to check it out, I appreciate it. And
Cool.
it's something I'm learning and having fun with. So,
Yeah, I'm definitely planning
on
on checking
that-
this out.
everybody, thank you so much. And yes, Rock, Proven Conspiracy still going. Just slow. Some of this will get into Proven Conspiracies. It's just a bigger ask. So everybody have a wonderful day and see you soon.